Yeah, thank you very much for this very kind introduction. And as the last speaker, thank you also for the audience for staying here with us. That's amazing. And let's go. So as Joan very nicely said, I'm a lawyer, and I've been learning now, having worked with non-lawyers, and mostly members of other disciplines than humanities, that I have to seduce you to really like privacy issues. And let's see if I win you today. So, yeah, part of this work, which I will introduce you to now, has been developed in connection with the broader open science ecosystem, including many exchanges with the Center for Open Science, whose work many of you, I think, know very well. And that connection has been very valuable in shaping how we think about reproducibility beyond purely methodological questions. So let's see if I manage to move this forward. Yeah, so I will just use this one. Yeah, so who are we? Well, MIC, Miller International Knowledge. We are two partners, in total now 20 lawyers and collaborators, and we are involved in 50 plus Horizon Europe projects. Our clients are companies, but especially public institutions like the European Commission, GIZ, the Spanish government, because we are based in Spain, and other institutions. So we work especially for institutions, especially in open science questions, also equality issues, not only gender, but also race issues, ethics training, and in the granted projects. And as I said before, our relationship with the Center for Open Science, so in one of the Center of Open Science members is advisory board member in our project, in the IP4OS project. COS is advisory board member in IRISE, that's a project on reproducibility where we are also partner in. And we support the Meta Science Alliance, so I think we are very much aligned with all what we are doing. IP4OS is funded by the European Commission under the Horizon Europe Research and Innovation Program with this following project number. And it's a project, here you can see all the partners. It's a project that is 2 years, runs for 2 years, funded with 2 million euros, and our main objective is to promote the as open as possible, as close as necessary principle by integrating agile IP management with open science practices through a concerted IP-OS approach. So we have key achievements and deliverables, like, for example, the synergy framework. You can find this already on our website. We do a lot of outreach and awareness, and at the moment, currently, we are based on our capacity building in training multi-professional teams in how to best make use of IPS and OS principles and issues. So now, whenever we work in European projects, we have to focus, we are obliged, because the European Commission is our funder, and that's why we are obliged to focus on ethics issues. And two of them, and it's funny, I have to say it's funny, but two of these issues are human beings, how to deal with human beings, and the other one is data protection, privacy issue. So that would be considered an ethics issue on European level. And so maybe, and this is where I thought is the tension for your center, the BITSS center, because your initiative has done something extremely important from what I've been reading and listening today. Over the last years, it has made transparency and reproducibility central to scientific integrity, which is great and important. However, today, I would like to focus on this growing tension that many of you already are already experiencing, and I've been also listening to this in many of the speeches today. The more we push for openness and reuse, the more we encounter privacy, legal, and ethical constraints. And so, in my opinion, the key question is no longer, can we make research reproducible? And maybe rather, can we make research reproducible, reusable, and compliant in my world, in my EU world, GDPR compliant at the same time? So, okay. Yeah, let me start with a simple observation from practice from one of our projects, not IP4S, another project that I've been involved 2 years ago. It's called Dive Air City. You can read it here. This project was focused on the question, how are citizens, in our case European citizens, affected by air pollution in some selected European cities. And in projects like Dive Air City, we worked with health data, behavioral data, citizen-generated data, and highly sensitive categories like ethnicity, gender, location, etc. And under GDPR, even pseudonymized data is still considered personal data. Anonymization is often not realistically achievable, and consent must be specific and purpose-bound. And this means that many data sets cannot be freely shared or reused. As way of reminder, personal data also IP addresses can be considered as personal data, as well as device ID, cookies, usernames, and social media handles, and the rest you can see, but I think that's all familiar. You're all knowledgeable about this. Sensitive personal data would be health data, genetic data, biometric data, racial or ethnic origin, religious or philosophical beliefs, political opinions, trade union membership, sexual orientation or sex life. And misuse of this data can lead to discrimination and serious harm. We should not forget about this. Information is not personal data if it is fully anonymous, so no possibility of re-identification, or it refers only to legal persons, like, for example, company emails would be not considered personal data. And pseudonymized data, for example, replacing names with codes, is still considered personal data if a re-identification is possible, and this is possible in most of the cases. So personal data is used to make decisions about people, like, for example, jobs, credit, insurance, predict behavior, target advertising and content, and enable surveillance and social sorting. The thing is, and that's where I really try very hard to being very creative to make myself understand in these European projects to my colleagues, to imagine where we want to live in the future. In what world do we want to live in 50, 100 years? And now I don't know if you are knowledgeable of these movies, or at least one of them, like Gattaca, it's older, Anon, or the Black Mirror series. Yeah, they are rather dystopic movies, simulations of how we could live on Earth all together in 50, 100 years. And I want to challenge us to ask ourselves if this is the future that we want to live in. I don't want to live in a future where I'm controlled by data, robots, etc. But then, dear colleagues, we have to act now. Yeah? Then we have to get it right now, which data we use and for what we use it, and who do we allow to use our data. I go back to the slide before. Because in order to get this right, this question, how do we want to live together, it is interesting to observe our different governance layers. And from my perspective, it's the European layer, and I want to share now with you that you are the US layer in this case. And there's a tension. So in the European, whose responsibility is it to protect personal data? This would be the guiding question here on this layer question. So from my perspective, from our perspective, European Union, the answer is pretty much clear. Data protection for us is a fundamental right enshrined in the Charter of Fundamental Rights and operationalized through the GDPR, a regulation. It has to be applied by everybody, also you, and I will come back to this later. That means that processing requires a lawful basis beforehand, meaning you have to think of what you want to do, and then you think of which data do you need. You don't just get any data, but you have to get this right before. So you have to design first your project and then think of what data you need for this. Individuals hold rights like access, erasure, portability, and these rights exist independently of demonstrated harm. And the burden is on the organization or the persons ex ante. And if I'm not a US lawyer, but if I'm not mistaken, the architecture here is different. So there seems not to be a single federal equivalent to our GDPR. There seems to be a patchwork of sectoral laws and state regulations, and a model closer to permission until objection. And these are not just legal differences. They reflect different assumptions about where rights begin and who is responsible for protecting them. So now, where this becomes critical for research is that GDPR applies on an extraterritorial basis, meaning that even you in the US or US-based researchers, and you want to collect EU data, or you collaborate with EU institutions, like for example with us, or you analyze EU data sets, then GDPR will apply to you. This is very important. And this, in my opinion, creates a structural problem for open science. Why? We heard this morning about the FAIR principles. So FAIR principles encourages openness and reuse. GDPR imposes data minimization, purpose limitation, and transfer restrictions. So a data set can be scientifically open and legally non-compliant at the same time. And I would like to add that a data set can be scientifically open and legally compliant at the same time and still do harm. An example. This Monday, I was in Paris at the OECD talking about a similar topic, and I met one of the fathers of the FAIR principles. His name is Barend Mons, and he explained me that on the basis of applying the FAIR principles in India, they have been developing metadata sets on the tiger population, because they wanted to protect tigers in India. So they did all sorts of data collection on the location, etc., and they published this according to the FAIR principles. What happened is that some hunters took this metadata and found the location of the tigers and shot the tigers. So even if we do our research in a legally compliant and applying the FAIR principles way, it still can do harm, and we should maybe not forget about this. So, and even the legal infrastructure governing EU-US transfers remains unstable. Safe Harbor and Privacy Shield were invalidated, unfortunately. The EU-US Data Privacy Framework from 2023 attempts to restore transfers. However, it remains under scrutiny and litigation. So many more questions than answers. And that means that we researchers are operating in legal uncertainty, which is not good. So our services are built in response to exactly this reality. So we face a structural contradiction. Reproducibility requires access. Privacy restricts access. And most current approaches treat this as a trade-off problem, either reproducibility or privacy. We would argue that this is not a trade-off problem, but rather a design problem. So we already heard about the FAIR principles, and there is now going on, and I think Barend Mons, one of the fathers of the FAIR principles, he told me on Monday he didn't like this very much. There's now this movement of adding letters to the FAIR principles. So Stefan Verhulst, he is of Brussels, he's also in New York, he added an R for AI readiness. And Barend Mons told me, he was very indignated, that this is not necessary because FAIR, he told me, if he had read my article, he would have understood that this is already included. Yeah, the same with quality issues, etc. Okay. Sorry. So what we did in IP4OS, we took Stefan Verhulst's article, who added the R for AI readiness, and we added an L for licensing. Yeah, Barend Mons should have told us earlier. Never mind. And so the FAIR principles have been a major step forward. You mentioned it this morning. And now with the FAIR R, we add responsibly license for AI use. However, in practice, we still, and apologies, Barend Mons, see limitations. So FAIR assumes data can be made accessible. FAIR does not fully address legal constraints, my opinion, not the father of the FAIR principles opinion. And in my opinion, FAIR does not resolve GDPR obligations. For example, a data set, and I said this before with the tiger example, a data set may be perfectly documented, stored in an open repository, however, still contains personal data and lacks a valid legal basis for reuse. So it is fair, yes, but not reusable in reality. So the gap. That's why we from IP4OS thought we need to move forward, and that's why we proposed combining FAIR R with licensing, and now another layer, GDPR plus ethics, which now leads to a new question: is your data set not only reusable, but responsibly reusable? And here you can see what we have been developing from IP4OS, the FAIR, I don't even know how to pronounce this, yeah, FAIR RRL rubric for data sets. You can read this, download it on our website. This is a checklist where we wanted to make your lives easier as researchers and just check if you fulfill all these FAIR principles, but also the licenses questions. And we should now add also the GDPR issues here. Yeah, and now it should also extend to GDPR. Is there a lawful basis for reuse? Can individuals be re-identified? Does reuse respect purpose limitation? And reusability becomes conditional and governed, not absolute. So this would lead to a new concept. Reproducibility by design through privacy by design. And in Dive-City, this project I was talking about earlier, air pollution, how does this affect European citizens? One of the central principles is privacy by design. What does this mean? Data protection is embedded from the beginning, not added at the end, and we extend this idea now to reproducibility, because reproducibility must also be designed from the beginning. And this leads to reproducibility by design built on data minimization, controlled access, structured consent, and clear licensing. So instead of asking, can we share this data later, we could ask, how do we design data so it can be reused responsibly from the start? So pretty much following your idea, yeah, of the framing. And to this we add the governance layer from IP4OS, where we focus on governance structures, licensing models, data sharing agreements, and we move from open versus closed to controlled openness, meaning that data can be accessed under defined conditions and with clear responsibilities. Now I come to my final slide. Again, taken from the project Dive-City, because I wanted to be concreter now. imagine this, my research team studying the impact of air pollution on citizen health in any European city. So they collect, as I said before, sensor data on air equality, wearable data like heart rate, activity levels, etc., survey data on well-being and lifestyle. What is the challenge here? That this includes special categories of personal data. Full anonymization is difficult because data is granular and longitudinal, and data cannot simply be uploaded to an open repository. So the traditional outcome would be data remains closed. We don't want this. Results cannot be fully reproduced, and AI models cannot be trained on the data set. Now comes in this framework. I call this the responsible data lifecycle. I was responsible for this task in this project, and I will walk you through this now. In the planning level, this would mean define purpose-specific consent, research and controlled reuse, and identify which data is strictly necessary, applying the data minimization principle. Then we go to the generating part, collect data with structured consent and clear participant information and avoid unnecessary identifiers. We come to the processing part, apply pseudonymization, separate identifiers from data sets, assess re-identification risks, and we come to the sharing part. Do not fully open the data set, instead create a controlled access repository. Reuse, provide access under conditions, data use agreements, licensing terms, and ethical approval where needed. And then the result, researchers can replicate the study under controlled conditions, data is legally reusable, and AI models can be trained in secure environments. That means that reproducibility is preserved without violating privacy. So now I come to the end, and let me conclude with one idea. The BITSS has helped define what good science looks like, and congratulations for that. Now I would love to invite all of us to ensure that this science can be reused, can be trusted, and can operate in a world of AI and data regulation, which would lead us to the following goal. Reproducibility is not only a methodological issue, it is a governance challenge. Thank you very much for your attention. And I'm now happy to take any question, and I hope they are not too difficult. And apologies if I don't understand them at the beginning. I'm highly jet-lagged. No questions. Not even you. You had so many contributions. Now I really expect something from you. No, please, jump. Come on, come on.
Mm-hmm. In theory, institutions can have replication boards that will give you a stamp that that research has been replicated independently in that university or elsewhere by a different team, and therefore you wouldn't necessarily need to have an outside audit if we agree on what the standard of that is. And I was wondering if you have any insights on how that is happening in the EU.
Yeah, so in the EU we are 27 member states. We don't even speak the same language. We have 24 official languages, and I would not understand Hungarian. I speak 4 languages, but not 24. And each country has its own culture, meaning it highly depends. Universities are very independent in the 27 member states, so they would, on an independent level, decide case by case. And so we have been encountered the fact that whereas in medical schools or in the natural sciences, or you call it hard sciences here, you always would need an ethics approval, whereas in social sciences or humanities, where I come from, we sometimes don't even have an ethics committee, or they would rather be very astonished, in humanities, or they would rather be astonished about questions on ethics approval. So I think this is not very clear neither in the European Union. Does this help as an answer?
Yes, because I'm sort of seeing it when someone leaves a will.
Yeah.
We've seen that any data that's protected currently becomes then released by humanity after 50 or 100 years becoming in a public domain. So a lot of these things that we are now protecting, we will maybe later release. And I think that becomes a bigger challenge because a lot of this data, today we're saying we strongly agree that it's not going to be released, and then later we do. But I think that's where a lot of these ethics questions sort of happen. Is that
I could not agree more with you.
we don't respect the choices done by those generations.
Yeah, and that's why, honestly, I really want to invite us to think of the future that we want to live in. Yeah, and if we have this clear, then let's go for it. If we want to, and I want to avoid this. Yeah. Yeah.
Yeah, thank you so much for the very wonderful presentation. So from my understanding, the framework that you described today is mostly built around the GDPR, right? Mm-hmm. And, privacy, as you probably know, can be highly contextual, and it's often, influenced by things like, who's collecting the information, for what purpose, but also things like cultural norms and so on. And so I was just wondering how scalable this framework actually is potentially to other places, right? Because even things like consent, the way we think about consent in the US, for example, can be very different from Europe. So I'm just curious how scalable your framework is.
Amazing. Thank you so much for this question. Yeah, I hope it is, for me, in my world, it is scalable because it applies just to any discipline. The thing is, not many people embrace it. And this is, I don't know, nobody likes lawyers or law or anything related to law. And this is our biggest issue, I think. But I think that this framework would work for any discipline, really. Yeah.
So maybe a bit more anecdotal, but I know some very excellent researchers who are like truffle pigs for finding personal identifying information. Like they just open a folder, or they go through loads of them and they just find it. And I think it's such a shame that I have no clear way to recognize them for their work, right? Where we don't want to draw attention to their, taking the PII off and saying that it's no longer accessible because that would kind of expose the fact that this was once available. Yeah. And so do you have any ways that we could maybe promote that or like positively reinforce people coming to ethics or coming forward with those types of issues?
Yeah, a super question. If you have ideas to engage, come and, I don't know. It's, don't know. No, I don't. I'm trying error, yeah. So I think that's an ongoing communication issues, and I'm really I have now discovered this, and I'm really bombarding my colleagues with this, and say if you want this, then okay, we can continue like this, and if not, we have to do something about it. Like more conceptual, because if you only say like a lawyer, this is not allowed, but you don't explain why, you lose people, Okay,